David, are you here? Yes. I'm probably supposed to be the bad guy today, right? The privacy guy, the human rights guy, the one who defends reputation, the stuff you don't like. Let's get a debate on that. I'll be looking forward to that, David. Thank you for inviting me. Okay. Let me start with the notion that some of you, I believe all of you heard about, but I'm not sure you really know, and bear with me, what it really means. The right to be forgotten. You heard about it, right? Now, let's just test. Who thinks that it's a good thing to have the right to be forgotten? Let me see some hands. Okay, got 2 here. 3. Only 3 in this group. Okay, 4. But certainly not the majority. And those that didn't raise, I should also ask who thinks that it's a bad thing. Okay, so a lot are undecided, right, David? I like that. I want to talk a bit about the right to be forgotten. I want to explain to you what it is, and especially what it's not. There's a lot of mythology about it. I want to talk about reputation. I want to talk about how it affects people's lives. I want to talk about the GDPR. I also talk about the business aspect of the right to be forgotten and the GDPR. And also, I'll try and adapt this a bit to this gathering, which is very tax-based. I'll get to that. Now, the right to be forgotten, I won't go into too many legal technicalities here, but it's really an interpretation made by the European Court of Justice in a so-called prejudicial ruling on the 13th of May 2014, pursuant to a request from the Data Protection Agency in Madrid. I think you all knew this more or less. And the question was really whether information that is true should be accessible on the internet forever, even though that information may no longer be relevant. Relevant is the term used by the judgment, and may disproportionately affect the individual who's mentioned in that piece of content. In other words, destroying his life. The European Court of Justice came down with a decision which actually was pretty remarkable, because it was the opposite of what the Advocate General had suggested. Now, before we go into some of the details about that right to be forgotten decision, let me just this chart talks about reputation. And actually what the right to be forgotten is all about is a recognition of the importance of reputation. I was at a very interesting gathering with the American Bar Association in Brussels a couple of weeks ago. There was the European Commission had its annual privacy conference. And one of the commissioners actually suggested that the gap accounting rules now should include reputation as an asset. Today, reputation is everything. What we read on the internet really causes us to act as consumers and also in a social context. Does anybody know what astroturfing means? You know what astroturfing is? Astroturfing is a term which is used to designate the influence that the internet has on consumer choices. It's very often used by a competitor to drive another competitor out of business. There are very famous cases of astroturfing. Some of them involve Taiwanese companies, and most of them involve American companies. There was a very recent case involving TripAdvisor in Italy. And all of these cases really are a consequence of the fact that the platform economy we live in today really directs our choices. Just look at these enormous companies, and we will all understand why everybody advertises on them and how it has a direct impact on our consumer choices. That correlation is established. AstroTurfing is becoming a major problem, also a legislative problem, and it's really just part of the reputation risk that everybody in this room lives in. You actually don't know whether somebody who doesn't like you is going to affect your business or you personally with some blog that people will believe or are afraid of not believing. So that's what astroturfing is. This is the business aspect of the right to be forgotten, as it were, because the right to be forgotten is a private aspect. The lawyer just before me spoke about the distinction that is made in the courts in Liechtenstein. I found that very interesting, between commercial interests in data and private interests in data. You remember that's what he mentioned. And we make that distinction also within the GDPR, between the commercial interest in data and the private interest in data. But that distinction is becoming more and more artificial. One of the main flaws in the GDPR, and I personally know that the commissioner, the German commissioner Günther Oettinger, who actually had the GDPR voted at the European Parliament, is that it doesn't include commercial activities and it doesn't include legal entities. We need to wait for a new regulation that will protect against astroturfing in Europe. We have some case law, but it's mainly out of the US, and it mainly has to do with unfair competition, and it has to do with deceitful advertising and that sort of thing. But the reason I mention that here is that when we talk about reputation, it's an asset. Not only a personal asset, but also a corporate asset. And the GAAP accounting rules may very well, or should maybe, be affected by this recognition that for most companies, that is the most important asset they have. It used to be brands and brand names. That's no longer the case. Now, how do we account for that on the balance sheet? Do we depreciate on it? What are the tax consequences of selling a business in terms of the valuation of the reputational contingency risk or asset? All of that is something that you, as accountants and tax lawyers, have to take into consideration when you see the future coming, and the future is here right now. The problem of reputation, if we go back to individuals, is really ancient. There's this fantastic story about Aristophanes. I mean, everybody knows who Aristophanes is. This was this Greek playwright who was a contemporary of Socrates, and he wrote this play called The Clouds, and in that play, he was defaming Socrates, saying that he was perverting the youth, and his sophistry was subversive, and so on and so forth. In Xenophon's historic description of the court case that took place, where, as you all know, Socrates was finally convicted and sentenced to death, it's very, very interesting to see that the play, that Aristophanes' play, clearly affected the decision of the so-called jurors. Reputation and reputational harm created by other people is a fact that we have with us. There is a very important study in this country, in the UK, of the effect of social media on juries. Now, juries are not supposed to access anything relative to the case that they're judging, but they're human. How can you stop them from accessing Twitter or Facebook and seeing the stuff out there? How does that affect their judgment? That is our world today. That is why, in my opinion, and I know that you don't agree at all, David, and we will have this debate, but I'm glad to see that not too many people are a priori against the right to be forgotten. That is the general context under which we must view the decision of the European Court of Justice. I should also say that between the recommendation made by the Attorney General and the court, which arrived at the other decision, as I said, we had the Snowden case, and that also affected quite a lot the decision of the European Court of Justice. The right to be forgotten is really a striking the balance call. A striking the balance call which is unique to European law. I say unique to European law because it's so different from American law. In Europe, we have some 30, maybe more, maybe less, human rights. And the European Court of Human Rights has consistently stated that there is no hit parade of human rights. They're all equal. They're all equal. And when it comes to balancing, for instance, free speech, Article 10, against, for instance, privacy, Article 8, it's not that free speech is better protected or is a superior right. It is not. All rights are the same. It's not that is not the case in the US. The First Amendment is not just the First Amendment in terms of numbers, it's the overriding right, which has led to the Communications Decency Act from 1996, which in Section 230 gives the internet service providers, that is the search engines, the social media, the hosts, the tech companies, absolute immunity from content. That's completely different from the European approach, which is crystallized in the e-commerce directive from the European Union from year 2000, which is a relative immunity approach. It's very, very important to realize this clash, because that is what we are moving towards, and I'll explain later how it will actually translate into real cases, this completely different cultural approach. Before we get to how it really works, the right to be forgotten, how many here actually assist clients in tax audits and tax controls? You do that. Have you ever seen that in tax controls and tax audits, the tax administration in your country has used as evidence information on social media against your client? Yeah.
I remember an inquiry a few years ago where actually the person had put the information out themselves, saying that they were founder, chairman, CEO of a business structure in order to big themselves up, if you like, in sort of common
Absolutely.
parlance. And actually there's a job to do there explaining, well, actually, no, this person doesn't call all of the shops. There's structures owned by a trust. The trustees have ultimate discretion. This person likes everybody to think that he runs it, but actually he doesn't.
Yeah, this is a very typical case. And again, I come from France. I can tell you just yesterday evening, the French Minister of the Budget, who's in charge of tax audits, came out with a clear strategy saying that now he will instruct all tax inspectors all over France to use social media as the data that they will officially be seeking information from, and also as evidence in cases. The IRS has already stated that officially. This country's Customs and Revenue is also. If you look up the internet, you'll see so many cases where people are simply judged on the basis of some stupid posting that somebody put on the internet, sometimes themselves, which makes it impossible to get down, or sometimes someone else. This has to do with the domicile. If they claim they don't live in one country and then they have all these photos of them taking their children to school in that country. It has to do with standing in front of the Ferrari, or the house that they said the value was like 1 million, but they forgot to declare the indoor swimming pool, which is all over Facebook. This is the kind of stuff. Now, I'm not saying that the tax inspectors should have access to that. What I'm saying is that we have to be extremely, extremely careful with what we are doing on the internet in general. Our reputation is 100%, not just 99% dependent upon that. I get cases almost every day from all over the world. I'm not exaggerating. Of people who tell me stories of how their life has been destroyed, typically not because they put something up themselves, even though we see that with teenagers growing older, but also because somebody else put something up. There's a terrible case. It's out public now, but I won't mention the name. This is a case in the US. This guy, you may find it afterwards. This guy, he had like third generation of a jewelry shop. And he fell out with someone, and this someone is based in India. and he started blogging against the individual and the jewelry shop, calling him a criminal, a fraudster, and so on, and it affected his business immediately. Now, what he did was he obtained a defamation order. Now, it's very, very hard to get a defamation order against somebody who lives in another country, let alone if he lives in the same country, especially in the US. But he got it. It took him 2 years. And it cost a lot of money. Finally gets the defamation order. Now, the problem with defamation orders on the internet is that you have to specify the URL, right? The specific page that you find defamatory. And he got that. But, of course, the guy over there in India, he simply took that content and put it on different URLs, right? Nothing is easier than doing that. It's a 10-second thing. You may say that maybe he made a mistake in requesting a court order not including a so-called stay down, which means not just take down, but also stay down. He may have made that mistake, I don't know. But so he won the case, and it's taken down, Google takes it down, but then it comes up again immediately. This guy, just to show you the level of desperation, he never committed a crime in his life. He inherited this business and just wanted to go about doing it. What he does is that he takes the court order, he adds the new URL, and that's forgery. He sends that to Google, right? That's forgery. He was found out, and he now serves a prison sentence of 9 months of forging an official court order. But why did he do that? I think everybody may understand that this person, I mean, his life was completely destroyed. His family, he had nothing left, and he knew that he would win another case, but it would take him another 2 years and cost him money that he doesn't have, because he spent all the money he had on winning the first case. This is what we're talking about. I get cases not like that. This is not my case. You can read about it. Maybe you can find out which one it is. But I get them all the time. And when I mentioned before the difference between the US and Europe, many of the cases I get are actually from US citizens. US citizens who are not protected by the European GDPR, because data subjects in the GDPR are defined as individuals, as informational individuals based within the European Union. So if you're based in New York or something like that, simply you cannot avail yourself of the GDPR. Only American law applies. They're reaching out to us in Europe, saying, help us, because they have the same situation as this guy, being completely driven. The latest case I have is from an investment broker in LA. Can we help them? Can we not help them? Some of them have dual nationality and say, does it help if if I'm half Spanish? Sorry, it doesn't. So the point I want to make here is that even though the American tradition is very, very much for free speech, we're all human, we all suffer the consequences of somebody destroying our life. And if I had more time, I could give you, unfortunately, hundreds of cases where you simply don't know what to do. And these people are all innocent. So let's just have a look at what the first distinction we have to make. I'm sorry, this is a busy chart, but that is taken directly from the GDPR. The first distinction we have to make is between defamation, in the original sense of the word, which means that it's inaccurate information, it's false information, and the right to be forgotten. Now, what you will see here is that it's fairly classic in terms of defamation. I'll now go to Article 17, which is the right to be forgotten, and then I'll make a point on the difference between the two of them. Okay, so this is called the right to erasure, because the right to be forgotten is what you see still in brackets. And it talks about data which was accurate, but is no longer necessary in relation to the purpose for which the data were collected, otherwise processed. Actually, you may have noticed this already. The the irony is that it's easier to scrub data about yourself if you're under Article 17 than if you're under Article 16. Because the real thing is not really getting it off the original site, right? The real thing is getting it off the search engine. If it's not immediately accessible on Google, forget about it, it's not a problem, even if it's out there somewhere. And Article 16 does not give that protection, while Article 17 does. In other words, the so-called controller, and that's a key notion in the GDPR, the controller as opposed to the processor. I'm happy to develop that later if we do it during a Q&A. But the controller is Google, very, very, very typically. And under Article 17, Google may have to de-index or dereference a site which is no longer accurate. While under Article 16, since it's defamation, Google does not have to. That makes no sense to me, but that's the way it is. Now, I made a very important point here is that the original content, the hurtful content, is not taken down, right? It's not taken down, it's still out there. And you may ask yourself, how come that's not taken down? I mean, we all know, as I just said, that if it's not accessible on Google, that's fine, but it may still be accessible. It's still out there. How can we actually read that into Article 17? That is, that the content as such is left up there. Well, it goes a bit further. It's in Article 85. And to be more precise, Article 85.3. And let me explain, because this is important to the journalists in this room, and especially to David. The original investigative journalism, the original content is never taken down. It's always out there. In Article 85.3, each member state must notify what is called the journalistic exemption. When I last contacted the European Commission to ask how many countries notified, was like about a month ago. Countries had not yet done it, even though it entered into effect on the 25th of May. But just a couple of days ago, I got the list. And almost all member states have notified under Article 85.3 that the journalistic exemption as provided for in their national laws applies. So there's really no problem of saying that there should be a direct attack, so to speak, on free speech. It's only the controllers, i.e. the search engine in this particular place, that is affected by the right to be forgotten. The right to be forgotten has given rise to quite a few questions, as you can imagine. The first thing that happened after the judgment of the 13th of May 2014 was that the so-called Article 29 group, which is a group of data protection agencies in Europe, they all got together and they said, okay, fine, what do we do about this? And Google also established what they call an advisory board to say, how do we deal with this? And what they did was that they created certain categories. And of course, there is one important category, which is that of public figures. Public figures very, very, very rarely can be protected by the right to be forgotten. It's deemed that once you're public, you expose yourself, nobody has to do it, you ask for it, and if you're being attacked and if you're being defamed, remember Article 16, Article 17, it's your problem, live with it. That seems to be very true. But look at the trend that we see in many countries in Europe right now on fake news. In France, a bill is now being, most probably will be adopted by the National Assembly, because the Senate, even though they vetoed it, don't have the right to stop it. And we've seen in other countries like in Germany, under the pretext of protecting democracy. Actually, what is happening now is that those that govern us, public figures, in reality want to be better protected than the rest of us, Because the fake news that is dangerous or allegedly dangerous to democracy is fake news about them, right? It's not fake news about you in this room. It's fake news about them. So we have a very, very interesting conflict here where the new legislation, which I totally agree with David, is a direct assault on journalistic freedom and free speech, which is the attempts to control fake news, is actually a protection of public figures under the guise of protecting democracy, which is blatant contradiction with the principles of the right to be forgotten and the GDPR. Very interesting development. The right to be forgotten decision, and I'll get back to some of the technicalities also because this is a group that's interested in tax, refers in 3 of the recitals to a legal notion that has never been seen before in international private law. And that is the notion of inextricably linked, or indissociablement lié in the French version. This should interest you from a tax point of view. Because actually what happened in that case, and what happened in later cases, including a case that I ran myself, is that Google Spain, in that case, was actually liable for the acts and omissions of Google Inc. Now just think about that. The way search engines operate today is that there's a powers reserved to Mountain View, to Google Inc., if we're talking about Google, and we are talking about Google, all right? They're the only ones that have access to the search engines. They're the only ones who can take something, who can dereference something which the automatic web crawler has indexed. They can't do that in France. They can't do that in this country. They can't do that in Spain. It's a powers reserved. It's the crown jewels. And it's the basis for the tax structure, which is that Google's local subsidiaries in Europe, and for that matter, the rest of the world, operate as advertising agencies. They just sell publicity for Google, Mountain View, and they get some sort of revenue-based commission. I'm not talking about the flow of funds through Ireland and all that. That's a different story. In the case which we had against Google, we actually had them produce some of these intercompany agreements. In our case, it was with Google France. And I could, but I won't, disclose the commission that is paid. But I just say that it is extremely interesting because, of course, the benchmark test, and I'm talking transfer pricing now, the benchmark test for that commission in terms of arm's length should be a wholly independent contractor, non-affiliated, doing exactly the same thing, right? That's our religion. That's OECD guidelines. Now, when you talk about one subsidiary being inextricably linked to another, with the legal consequence that the subsidiary has a joint and several liability for the acts and omissions of the parent. Our friend from Liechtenstein was talking about piercing the corporate veil the other way around. That's what I'm doing now. When you talk about that, I dare the tax administration, or I don't know who I dare, but the tax administration, I know they're actually looking at it in one country, to see whether the commission that is paid to the local subsidiary is really arm's length. Because a non-affiliated advertising agency, it would never be jointly and severally liable with an unaffiliated business partner, and would either have to table that as a contingent liability or ask for a commission which was way over above what the non-affiliated party gets, right? So we could make that case. And I think that is one of the cases that they are looking at now, tax administration, as one of the many consequences of the right to be forgotten, which of course not based on reputation and so on, but on this new concept of inextricably linked. we obtained, just so that everybody sees how this translates into in real terms, we obtained daily penalties against Google France until Google Inc. de-indexed certain sites, all right? So this company in France has to pay penalties until somebody else does something. That's pretty interesting, isn't it? So that's one of the consequences of the inextricably linked portion of the decision. But of course, the main reason why the European Court of Justice came down with that new concept was not tax-driven, but it simply had to do with obtaining jurisdiction over, in reality, Google Inc., but through the local subsidiary. And that brings us to another question which really relates to what I said before, which is this clash that we are moving towards in terms of the free speech, absolutism, almost religion in the US, and the European approach, which is all human rights are equal, and we have a relative immunity approach in the e-commerce directive. One of the main problems related to the right to be forgotten from an international law point of view is really, can the local data protection agency in the UK and whatever order Google to take down content which infringes either Article 16 or 17 worldwide, all right? That's the global reach problem. Can the DPA, the Information Commission of this country, order Google to take down content on the domain name .com, or can she only, Elizabeth Denham, order Google to take down content on .uk, .france, and the rest of them? This is one of the main legal questions we have today, not only on the internet in terms of the right to be forgotten, but in terms of the future of the internet. And it really also affects VAT, sales tax, and a lot of other consequences does it have. What is the jurisdiction of each country, and what about territoriality or extraterritoriality? That question will be decided by the European Court of Justice, most probably in 6 months, pursuant to a request for prejudicial ruling submitted by the Conseil d'État, which is the top administrative court in France, last year, where the French data protection agency, CNIL, fined Google, now this is Google France, 100,000 euros because Google Inc. did not take something down on the domain .com. Of course, it was a test, and true enough, that question is now before the European Court of Justice. Extremely important because it since 1927, the League of Nations, we have not had an international case dealing with this jurisdictional clash. And unfortunately, the difference between the US approach and the European approach is growing bigger and not the opposite. The Trump administration seeks to include in the new WIPO treaties, that's intellectual property, and the new trade agreements, a safe harbor provision for US tech companies like the Communications Decency Act 230, which is the one I just described, which is the one on absolute immunity. Now, people don't talk about that, but it's in there. At the same time, and that happened between Obama and Trump, the so-called Cloud Act passed. And the Cloud Act in the US gives the US government, including the tax administration, access to evidence which is hosted abroad. That case was the Microsoft Justice Department case, where the Justice Department, in an investigation, wanted information from Microsoft, which was lodged on a computer in Ireland. And Microsoft simply said, we can't give you that. That would be a violation of the data protection agency, of the data protection laws in Ireland. And you have to move either through an MLA or some other procedure. We can't give you that. then the Cloud Act was passed, which gives the US law enforcement establishment the right to get evidence from US-based companies, even though that evidence is based abroad. It doesn't even take a court order. You can very well see that extraterritoriality from the US side, including, by the way, export regulations. There's a famous case of this guy. He put out a blueprint on how to produce a handgun with a 3D printer. Did you hear about that case? How to produce a handgun with a 3D printer. It came out last year. The judgment was this year. And actually, he violated the US export regulations because this was weaponry and this was an export of US technology. Clearly, extraterritorial application. So what we have now in Europe is the same sort of thing, that we want our laws, especially our court orders, to apply also in the US. Everybody can see the clash that we're heading against and how exciting those times are going to be. And I don't envy the judges at the European Court of Justice sitting with that extremely hot potato. Let's now move, because we talked about European law, and we also talked about member state law. There's also some international law here. How many knew that this one existed? The International Right of Correction? It exists. It's a UN treaty. Nobody knows about it. It exists. And actually what it provides for is that, okay, it's a long preamble, I don't expect you all to read this, but look at this one. It says that as a matter of professional ethics, information should basically be true. This is an international legal instrument that obligates a state, member of the United Nations, right, to ensure that under their national laws, they will enforce this treaty. Nobody knows about it. Everybody forgot it, but it exists. I also want to show you this one. The International Convention on the Use of Broadcasting from 1936. This is another international instrument from the League of Nations time. The reason I mentioned those two is that this conflict of how far does the right to be forgotten reach, and all the other rights in the GDPR, is not only a consequence of European law and member state law, but we have these treaties. And this one is, in particular, is very interesting because as you can see, it was between World War I and World War II. And it came out of a conference that was called the Moral Disarmament Conference, which started in 1931. And it dealt with propaganda between countries. They didn't use the word fake news because it didn't exist. But that's what it is. Propaganda between countries. Unfortunately, it in no way prevented the biggest propaganda machine from starting a couple of years later under the auspices of Goebbels, but it certainly had high ambitions, and we shouldn't forget that one. The idea is that a state is responsible for content originating on its territory. That in those days we didn't have the internet, we had broadcasting. But of course it can be applied to the internet. And if you look at the other one that I showed you, the first one I showed you, which is the other UN treaty, which is much newer, it's basically the same idea that states should accept that they shouldn't, on their territory, allow information which has a nefarious impact, either on friendly relations between governments, you can also find that in the UN Charter, Article 4, or individuals and companies and so on. Now, I'm just looking forward to the first case before the International Court of Justice, I know some of the judges there, and unfortunately there is no pending case on this. I'm just waiting for that case, because this seems to be what we need in today's global society. We need to remember the obligations of states vis-à-vis each other. Let's take the allegations against Russia for meddling in the US elections. Now, nobody has actually in that discussion talked about the responsibilities of the Russian Federation under international public law. Everybody's talked about Cambridge Analytica and Facebook, and maybe or maybe not, there's evidence. On the 20th of April, the Democratic Party sued the Russian Federation in New York. They sued the Trump campaign. They sued the GRU, the Secret Service of Russia, for meddling. But I think that the right remedy would be international law. Because the beauty of that is that even if you cannot prove that the Kremlin was behind the so-called manipulative activities, I say so-called because I haven't seen any evidence, you don't need to prove that under international law. Negligence is enough. There's a leading case to that effect before the International Court of Justice, which was the case of the hostages in Tehran, where actually Iran was found to be responsible vis-à-vis the US under international law for being negligent in protecting or not protecting the US staff at the US embassy in Tehran in those days. Nobody said that Iran was behind the hostage taking, but what they said is that they were negligent in not ensuring the safety. And you could actually maybe make that case involving the Russian Federation here. You don't need to prove that they knew about it, were behind it, but maybe they were negligent. So the reason I speak about all of this is that the right to be forgotten, and now I will get back to how it works in practice, is really much more important than we believe. It's not just a right that's related to an individual, it also encompasses astroturfing, reputation, tax, international law of jurisdiction, extraterritoriality, all of that and even more. It's a watershed decision. I really cannot exaggerate the importance of that decision. So how does it work in practice? Again, if you, as lawyers or whatever, if you get somebody or yourself, you want to take something down from Google, again, the irony is that if it's defamatory, it's false, it's harder to take down than if it was originally true but no longer relevant. We saw that in Article 16, which is defamation, and Article 17, which is right to be forgotten. So the way forward is use Article 17, forget that it was never true, but simply say it's no longer relevant. Google has a formula that they developed for this. They received probably a couple of million, probably that's it from Europeans today. And I've filed that very, very many times in different jurisdictions in Europe, and it works. I think the official statistics are like 45%. I may be wrong, but maybe 40, whatever. Of all such requests are actually accepted by Google, provided they don't relate to public figures, provided they don't relate to that they're not newsworthy. Of course, if they are newsworthy, they are still relevant, right? But it's mainly the public figure kind of thing and the newsworthy thing that when we don't get Google to accept it, it's mainly because of one or the other or both of these considerations. And then what they do is they will, if they accept it, dereference it on they dereference the URLs that you asked for, and they will do it on European sites if you asked for that. Now remember, the URL is going to pop up again. It's whacking them all. Just the example of this poor gentleman who's now in prison. So what you need to do is to ask Google to make sure that it's not just notice to take down, but also stay down. Now, Google hasn't accepted that as a policy, but they have a problem by not accepting that. And that's intellectual property rights. You know, you're going to ask yourself the following question. Why should personal creativity deserve better protection than personal integrity? Just think about that, because that's the law. Personal creativity is protected by copyright, by intellectual property rights. But an infinitesimal group of people really reach that level of creativity. That's protected. But we are all born with integrity. That's not protected. Just think about it. So Google's dilemma is that when it comes to infringement of copyright and IP, for instance on YouTube, they're very careful. That starts costing money. So they actually monitor. It's not like only after they get a notice. They actually monitor whether the video in question, the music in question, and so on and so forth, is copyright protected. They're proactive on this. They have no problem with that. And when they take down something, they automatically make sure that it's staying down, that the word is take down, stay down. And if you want to read more about it, it's in the DMCA, the Digital Millennium Copyright Act, Article 512. So Google can do that when it comes to intellectual property rights. That's why they have a bit of a problem saying that we can't do that when it comes to other kinds of URLs where the content is exactly the same. So of course they can. So a clever drafting of a request to Google is to include as many URLs as you can, and then include a request for take down and stay down, and request that it be taken down on all domain names in Europe, because they won't do it on .com until we have the decision from the European Court of Justice, whichever way that one goes. So if you do it that way, you will have a pretty good chance of succeeding in protecting your reputation, protecting your business, and actually, as many people have told me, get your life back, because that is what it's all about. Now, I've been a bit passionate about this, as you can probably see. It's important to me. I have no doubt that the right to be forgotten is a human right. There may be some discussion about that, but personally I have no doubt. I'm actually writing a book. I do some work for UNESCO, and I'm actually writing a book right now on whether the internet actually protects human rights. So the right to be forgotten is certainly going to be a human right in that book. And I seriously feel that this is a major step in the right direction. So sorry, but I have to leave in a couple of hours because I'm actually on my way to a UNESCO conference in India. They're very interested in this. So if you want to talk afterwards, I'll probably be leaving in a couple of hours. But let's see whether you have some questions right now. I'd like to ask you one of the questions here is that who thinks now? Well, people are leaving the room, so I don't know. Who thinks now that we should have a right to... Who thinks that it's a good idea, the right to be forgotten? Thank you. Yeah. You know, I gave a presentation, not exactly the same, because there was more American law in it, Supreme Court case law, to the American Bar Association back in June in Paris. There were like the 250 of the biggest law firms in the U.S., and there were prosecutors, there were district judges, there were federal judges, and it was really very, very interesting because more than 50% of this group actually thought that they should have the same in the U.S. That's pretty watershed. Now, does Cambridge Analytica have something to do with this? Of course. Does concentration of information in the hands of 2 or 3 companies that know everything about us have anything to do with this? Of course. So I strongly believe, and I hope, and I'll fight for the universal acceptance of the right to be forgotten as a human right. You had a question?
Hi, thanks. Does a successful request take down a URL for any search term or for a specific search term? And is information shared between search engines? So if you request one from Google, would you need a separate one from, say, Yahoo or Bing?
Sorry? Whether Google shares it with the author?
If you request the right to be forgotten, presumably you have to do that separately for each search engine, or is information shared there as well?
The Article 29 group that I referred to before, which is this special group of data protection agencies in Europe that got together after the right to be forgotten to come up with guidelines, which, for instance, include the category of public figures, also dealt with the question of whether the search engine is under an obligation to advise the author of the impugned information or content that such a request has come in. And there is no such obligation. Now, but does that mean that Google doesn't do it? We really don't know. We really don't know. In my experience, they haven't done it.
I have a question. In the United States, can the anti-bullying laws actually be used for adults or businesses that have been defamed or have negative information about them on the internet?
Yeah, you're right. There are laws in the US that classify certain speech as unprotected, right? And unprotected speech would be cyberbullying, would be pornography, it would be sex trafficking. The latest law, the SESTA and FOSTA, deals with sex trafficking. It would be incitement with an imminent risk to commit a criminal act, and so on and so forth. There are certain categories of speech that are not protected under the First Amendment. And under state legislature, this is not federal law, for instance, in California, especially with the Consumer Privacy Act, which was passed this summer, under the auspices of Alistair McTaggart, a great guy. He really invested millions in getting this law passed. You will find such protection, but it only applies in California. That's the way it is.
Hi, I'm Richard Brooks, journalist. I wonder if you know much about how organisations like Google make the judgment about relevance and where they get their information from. It seems to be one of the problems is you're going to get plenty of information from the person who wants something to be forgotten, explaining why it's no longer relevant. But the people who might consider it relevant aren't going to have much input into the process. They might not even know about it.
That's a very, very good question. It's almost like this conference. I was at this conference, the Global Forum, last week in Copenhagen. And we were on a panel with the public policy officer from Facebook. And we were discussing Facebook's fact-checking in terms of fake news. You know, how do they recruit their fact-checkers? What is their incentive? Is this a career path for them? How many so-called facts do they check every day when they're sitting out in Bangalore, India, right? It's almost the same thing. The people that review such right to be forgotten requests on this standard formula, which is the same, by the way, in all of the European Union, who are they and how do they review this? The answers that we received do not in any way demonstrate that it has gone through a legal analysis. It seems to be very, very, very standardized, and of course we have to be fair. It has to be, because if they receive thousands every day, it has to be fair. We have to be fair. But it is indeed very, very, very standard. And apart from this public figure thing, which will immediately disqualify you from any protection, and some newspaper articles that may, at that point in time, would they receive it, be dealing with the question. Apart from these two things, which are objective, I'm sorry, I can't tell you how they actually view it. But judging from the answers I get, it's very, very, very standard. And we could have hoped for a much more individualized approach. The thing is that Google does not have direct liability once they review it. Of course, you may then say, is a standard answer a review? That's a good question, right? But let's just assume or imagine that it is. Then they are no longer liable. Because liability, as I mentioned before, in Europe we have relative immunity, not absolute immunity. Liability of Google assumes either that the content is manifestly illicit. That's what different courts throughout the member states have said when they interpreted the e-commerce directive. So manifestly illicit would be typically something like hate speech or something like that. That would be manifestly illicit, and even there you can discuss it. But if something is manifestly, or pornography or something like that. If it's not manifestly illicit, and if they review it, even if the review is very standard, they are no longer liable under the mere conduit rules in Europe. Liability disappears this way, and they've done their job. And this is one of the main problems we have with enforcing the right to be forgotten. And this is why I'm very pleased that the European Commission is revisiting the e-commerce directive, which will allow, hopefully, greater intermediary accountability in general for content as a consequence of Angela Merkel's law on hate speech and fake news. But today, I'm afraid that just such a standard letter, which hasn't been reviewed by anybody, gives them a safe harbor. Sorry? Okay, we wrap it up? Okay, fine. Okay, we don't it's fine. We don't have time for more questions, and I know that this presentation was very different from the rest of them. I think that's why David invited me, not just to be the devil's advocate, but to talk about something completely different. And you're very welcome to write me a mail if you want some of the information that I just sent you. I'll send you links. I'll even send you a link to the jeweler whose name I didn't give you. Okay. So I hope you enjoyed it. Thank you.